Hello everyone, so welcome back to my English Law channel. So I'm looking at severance of co-ownership now. Well, how does that work? So that's whereby a joint tenancy in equity becomes a tenancy in common, and that means there'll be no more right of survivorship or jus accrescendi, to use the technical term. So because only joint tenancy is permitted at law as opposed to in equity, you cannot sever the legal title. So if there are three or more co-owners in equity, severance will operate to give a common tenancy in common to the person who's severing. The others will remain joint tenants. Complicated, I know. Supposing we've got Arabella, Belinda and Charlotte, they're joint tenants at law. So they hold this for themselves as joint tenants in equity. Supposing Arabella severs, well then what happens? You're going to see so that she's a tenant in common holding a third of the property, whereas the other two are joint tenants and holding 2/3 together. All right, so let me see. So when severing, the share that a party gains is calculated by referring to the number of joint tenants, any of whom, remember, has an equal title to joint tenancy if they sever. And it's not according to how much the parties paid to buy the property. For instance, supposing Arabella paid 40% towards buying the property and Belinda and Charlotte paid 30% apiece. If Arabella were to sever, she would get a third. She wouldn't get the 40% that she paid. So go back to the Law Property Act 1925, section 36.2. So joint tenancy in equity can be severed through writing or by any other manner that would sever a joint tenancy in personalty. Personalty is personal property, like movables, as opposed to land, as opposed to realty. Real property, houses, land. So there's Williams and Hensman, 1861. There's a case about that. So writing is a unilateral act, as in it's by one party. So the joint tenant notifies the others that he or she is severing. So the writing must be enough to show intention that they wish to sever the joint tenancy instantly. Burgess and Rawnsley, 1975, is a case about that, or Gore and Snell against Carpenter, 1990. There's a plethora of cases on this one, but the rulings are rather inconsistent. You could look at Harrison Goddard, 1983, or indeed Ray Draper's Conveyance, 1989. So long as the writing is demonstrative of the needful intention to sever, then it severs on the other joint tenants. So you need to send it to the last place that you knew them to live, their abode, or indeed their workplace. You don't have to show that this notification was in fact read by them. They might not have opened it or whatever. So the severance is deemed to operate the moment it was posted. So as the moment it has arrived, it's not the postal acceptance rule as used to prevail in contract. So Judge Neuberger, as he was at the time, had to rule on this in Kinch and Bullard, 1999. So anyway, what destroys this notice is to prevent the other joint tenants from reading it. It was destroyed, so the severance was judged not to take place, even though obiter dicta it was said that the party who destroyed the notice, or therefore their estate, could be stopped from relying upon this hidden severance. The person couldn't derive any advantage from it if they predeceased the others. So it doesn't make any difference in the notice whether it's effectively delivered and whether this means the severance to the notice. So the sender of the notice signs for it on delivery. There was Ray 88 Berkeley Road, 1971, about that. So the writing doesn't need to be signed. It doesn't have to be in a particular form like a deed or something like that, and it doesn't have to be consonant with any formalities. If it's sent by registered post, it's considered to have arrived on the day it would have done in the normal course of posting, unless it's returned undelivered. So William Hensman, 1861, was about this. So Page Wood v.C. So there are three common law kinds of severance in equity. So one of them is a further unilateral act of severance, and that's made possible by saying acting on your share. So this requires the joint tenant to do something which is irrevocable as an act of alienation. Now, there seems to be a bit of a contradiction in this one, because even if this person doesn't have a share, he acquires one by acting on a share that he doesn't have yet. So this could be total alienation, for instance, transferring your beneficial interest to another, and that would comply with the requirements of Section 53.1c of the LPA 1925, or agreeing to do so under a contract that is specifically enforceable, so long as that it complies with Section 2 of the Law of Property Miscellaneous Provisions Act 1989. It could be partial alienation by mortgaging or charging of beneficial interests. So, in another way, if the person is declared to be bankrupt, that will automatically be severance of their joint tenancy, because the assets of the bankrupt party, including their interests under a joint tenancy, are vested in the trustee in bankruptcy at that moment. Okay, another way you could sever it in equity. It could be mutual agreement. There's Burgess and Rawnsley, 1975, a case about that. So they could have an agreement to make mutual wills, or to sever, or to deal with the land in a way that impliedly severs the joint tenancy. So anyway, this is severance by mutual agreement. Any of the ways I've just adumbrated. Bear in mind that a valid contract about land requires writing under the Law of Property Miscellaneous Provisions Act 1989. Burgess and Rawnsley is about the intention of parties and not about whether the formalities were properly undergone. So severance could happen even if the agreement that causes severance couldn't be enforced, because there's no formality. So the mutual agreement, it sounds like it goes without saying. I mean, it can't be an agreement if it's singular. It has to be between at least two parties. But anyway, the agreement has to include all the joint tenants, not just some of them, because they could be 3, they could be more. All right, so it could be in a course of dealing. We sometimes call this mutual conduct. So this is enough to show that there's common intention when one or more of the tenants want to regard as having an undivided share. So it's similar to mutual agreement in that the course of dealing has to be mutual, has to involve all of them and not just some of them. Gore and Snell against Carpenter is a case about this. Okay, homicide, unusual, I know. So by killing the other joint tenants, that doesn't mean that you inherit everything. As I said, it would be unconscionable, like Ray K, 1985, for someone to benefit financially from murdering the others, or indeed killing them through manslaughter. So anyway, severance cannot be through your last will and testament. So testators have to do it a different way. In Ray Kane's 1978, it must be inter vivos, as in amongst the living, because at the time the will comes into operation, any interest under the joint tenancy will have disappeared through this doctrine of survivorship. So it was said in Gould and Kemp, 1834, that the right of survivorship takes priority over any testamentary dispositions, as in wills. Okay, so beneficial ownership will not change the legal ownership. It's impossible to sever joint tenancy at law. The only way you can change this is if the legal joint tenant deceases, and then of course he automatically is off the legal title, because there's that doctrine of survivorship. That's enough for the moment. Toodaloo.